you're not ready to go in court. You're not ready to go in court yet. I'm always on the internet, and I get some consultations, and people have certain issues that they're dealing with. Perhaps you're dealing with a criminal case or even just a traffic ticket, and you're thinking about using this process to go into court to defend yourself or try to get a remedy, as some of you like to say, or just really what you're trying to do is just get some sort of resolution to it where you don't have to pay out of pocket and you maintain your freedom. Now, these processes have been around for a very, very long time of going into court, saying you don't have jurisdiction over me. None of that stuff is new. It's been around for probably over 30 years. You need to understand that first and foremost as well. You just haven't heard of it before, but it's been around a long time. And the courts have been dealing with it for about that amount of time as well. You just don't know about it. You may just be coming into the information and finding out about it, but trust me, it's been around for a long time. Now, I'm just gonna give you my experience and my opinion about going into court. This is an opinion. This is my opinion about going into court. But then it does kind of guide me when I'm consulting people and people tell me what their circumstances are, and then I give them some sort of suggestion on a course of action that they should take. First, the first thing I'm going to look at is how long have you been studying this information? How long have you been aware of this information? If you've just found out about this information and you want to go in court and utilize it, I can almost promise you, or almost be 100% sure you're going to have a very low success rate. All right, not to say that sometimes people don't get lucky and things work for them, because that, every situation is different. But for the most part, most of the time, you're not going to be very successful because, to learn this information takes a little bit of time. There are a lot of words you have to learn. There are a lot of principles you have to learn, things of that nature. You're not just going to come in through the door and start doing, going into court and getting resolution and just winning. That's not going to happen. That's delusional for you to think that way. The next thing I have to look at is how well is your ability to talk in court. A lot of people don't have a good grasp of the English language, and you can't go into the courtroom using ebonics and colloquialisms from the street and things like that and think you're going to get some sort of resolution. Okay, first of all, they're speaking legalese in the court, so you got to know the language that they're speaking. That's number one. And number two, it's like this is a gentleman's game. You're going in there, you're trying to defend yourself. You need to be able to speak in a certain kind of way. You can't just be just got this hood talk and everything. That's not going to work for you. All right. I appreciate the 2 bones, Sir Ray, and also Chief Baspo, the 10 bones, man. I appreciate both of you gentlemen. All right. Now, the next thing is your ability to think on your feet. Your ability to think on your feet. This is a very, very big one when you're going into the courtroom, because a lot of people, they like to come into the courtroom and perhaps read something from a piece of paper, some pre-prepared statement that somebody has given them and say, go into the court and read this and you're going to get some sort of remedy for yourself. Once again, you're going to have a very low success rate with that. You need to have the ability to think on your feet when you're in court, because you may come into contact with certain judges that's going to test your level of knowledge. They'll put your paperwork to the side. You'll hand them a paperwork. They'll hand you some paperwork and they'll get it and they'll just put it to the side and start talking to you and asking you questions. Because they want to see, okay, you claiming you are this sovereign. You're claiming that you're not a dependent, because this is basically what you're saying to them. You're saying to them, I'm not a dependent of the U.S. government. I'm not a U.S. citizen. Okay, I don't use any benefits or privileges. Primarily, I don't use the Social Security number. I'm not in any need of any benefits and privileges from you. And on top of that, I'm more than competent enough to handle my own commercial affairs. All right? Because the whole basis of everything that's happened in this country is a result of the New Deal under the Great Depression, when the American people went to the government for help, saying we can't take care of ourselves. We need you to take care of us. And the government made a deal. And that's when you had all these socialist programs that came into fruition, primarily the Social Security program, which I'm working on doing a video on right now, because we need to get some deeper understanding on exactly what Social Security is, because it's not an insurance program. It is a benefit and a privilege. Congress can take it away from you at any time. It doesn't matter how much money you paid into it. That's a gift, a class 5 gift and estate tax. I mean, you start studying this and you see what's going on. You see how truly delusional the American people are, and how the lack of understanding they have as to the function of their government, and just civics in general. That's a big problem in this country. But you got to be able to think on your feet. Okay, you have to. This takes practice. And it takes repetition. You got to say, you got to think in your mind, okay, if he say this, I'm going to say this. If he say this, I'm going to say this. You have to work over a variety of different scenarios. Like when you ask the judge a question, you need to anticipate certain answers that he's going to give you. Like I'm not here to give you legal advice. Well, sir, I'm not seeking legal advice. When I'm trying to determine is your legal intent. Now, the Constitution for the United States of America grants me the right to know the nation and cause of this action, and it makes it incumbent upon you, and it gives you the duty to provide me with that information. Now, sir, would you please give me the information on the record, because it is my understanding I have a constitutional protected right to know the information. Is that or is that not correct? You have to have some sort of response for things that he says. We're not here to talk about that today. Well, if we're not here to talk about it today, then I move to court for a recess until we can get it to a point where we can discuss it, because this is very important. What we need to talk about, it goes into the procedural aspects of everything we're doing. So so I need to abate these proceedings until we get to the bottom of this nature and cause of action, because I'm going to properly defend myself, Your Honor, if I don't have this information. You got to be able to think on your feet when they say something. You got to anticipate. That's one of the number one things. And if you're not willing to rehearse your lines, everybody rehearses their lines. They have lines. They are administrators. That means that everything they say in court is probably rehearsed, because they got to make sure that they don't go outside the ambit of their delegated authority, because they're operating in a legislative democracy, which means they have a ministerial duty to perform, which means they're not a real judge. They're an employee of the legislature, and they're doing the whims of the legislature, and the legislature will check them if they don't do what they want them to do. So we're in this venue, okay, and they prepared everything that they're going to say. You need to prepare everything you're going to say. You need to anticipate everything, every possible thing that they could possibly say. You need to be prepared for it. And you need to already have rehearsed a line to respond to it. So many things, like if somebody walks into the courtroom and starts talking, I'm sorry, sir, do you have a claim against me? I ask them a question, what is your interest in this matter? Do you have a claim against me? Why are you speaking on the record then? Who are you? Could you please state your name for the record, sir? All these little things matter. All these little things matter. The judge says, you know what, I'm going to go ahead and schedule this for trial. I'm sorry, Your Honor, but I thought I made it abundantly clear to yourself and this court that I'm not disputing any facts in this matter. So I would like you to tell me on the record how you taking me to a bench trial or a jury trial when I made it abundantly clear I'm not challenging any of the facts in this matter. I've agreed to the facts. I've stipulated to the facts. Now we need to get to the law. But in order to get to the law, I need to know what kind of law is being applied. In order for me to understand that, I need to know what jurisdiction we're operating under. And you failed to reveal that information to me under the authority of the Sixth Amendment for the Constitution of the United States of America. And now you're seeking to take me to trial under a secret jurisdiction that is only known to you and the prosecutor. How's that fair, Your Honor? Well, you need to be quiet. You say another word, and I'm telling you, I'm gonna hit you with contempt. Is that gonna be civil or criminal contempt? Additionally, am I to understand that you have made some sort of judicial determination that I'm not to be afforded my due process rights and freedom of speech in these proceedings? For the record,